Hello and welcome to today's news segment on the court case Fisher versus University of Texas at Austin. While Texas petitioner Abigail Fisher was denied admission to the University of Texas at Austin for the entering class of fall 2008. In response to her denied acceptance, Fisher sued UT, claiming that her 14th Amendment right to an equal protection was violated because she was not allowed admission to the university, while less qualified students of color were admitted. To better understand this particular case, let's look at previous cases. First, in 1978, the Regents of California versus Bake upheld affirmative action which allowed race to be one of several factors in the college admissions process. However, it also ruled that certain quotas, such as 16 out of 100 spots set aside for minorities at UC Davis Medical School, were not allowed. In the 1992 case, Hopwood versus Texas, where Cheryl Hopwood was denied admissions to UT's law school, which she said was due to unfair admissions of minorities, it went to the Fifth Circuit Case of Appeals in 1996, and the court ruled that the schools may not use race as a factor when deciding which applicants to admit. In 1997, in protest of the rule, the Top 10% law was created in an attempt to increase diversity by admitting the top 10% of each high school in the state. In 2003, Hopwood versus Texas was made null and void by the Supreme Court because of Grutter versus Bollinger, another case about admittance of minorities, which ruled that schools could obtain the education benefits that flow from a diverse student body. Now back to Fisher versus University of Texas. The District Court of the Western District of Texas ruled that admission process was in the bounds of the law. It was appealed in 2011 by the Fifth Circuit Court and again said it was in the bounds of the law. Again, it was appealed in 2012, and the Supreme Court agreed to hear it. In 2003, it was declared that the Fifth Circuit Court did not apply strict scrutiny, and so that the ruling was invalid and remanded or returned to the Fifth Circuit case, meaning that the Supreme Court did not make a decision. The Fifth Circuit case still sided with the university, however, and Fisher can still file an appeal. Groups in support of Fisher include libertarian public interest groups, members of the U.S. Commission on Civil Rights, and the Asian American Legal Foundation. The United States and 17 states and territories, members of the federal and Texas legislatures, educational organizations, and at least 117 colleges and universities, 57 Fortune 100 companies and other American businesses, and 21 small business owners and associations, and the social science researchers and empirical scholars filed briefs in support of the University of Texas. And now on to Abigail Fisher to hear her side of the story.
Hi, I'm Abigail Fisher. I know many alumni of the University of Texas, which is why I wanted to attend. My dad went there, my sister went there, and I knew many close friends that also attended. However, when I applied, applicants with lower test scores and class ranks were being admitted. They had race in their favor, and I didn't, and that's why they got in. I believe that it is unfair that these less qualified people academically were being accepted. From a young age, I was taught that any kind of discrimination was wrong. Judging someone based on the color of their skin, regardless of what color that might be, is wrong. It creates a bad, harmful, and toxic community for us to live and also learn in. College is supposed to be a time of acceptance and freedom. When schools restrict this acceptance or acceptances based on race, it is unfair. I think that colleges should get rid of boxes. Colleges do not need to know that I am a woman and that I am white. They should judge me based on what I will bring to their school. My grades and activities are more important than what I look like. I believe in a colorblind principle, and I want a colorblind admission policy. The government, in fact, did not support the level of inquiry, strict scrutiny, with enough reason to implement law. I hope that when people look back on this court case, they realize that I've stood up for what I believe is right, and I hope that in the future, the admissions process for all students will be unhindered with aid of a colorblind process and adhere to the equal protection clause. Thank you.
Hi, I'm a representative from the University of Texas. Race and diversity has been a problem before for colleges and universities across the country, and I recognize this problem is not one easily solved. And we, the University of Texas, have tried to combat that issue by creating a fair process. After 1997, the Texas legislature made law for UT to admit all high school seniors who were in top 10% of class, and we complied. It was decided that the University of Texas would modify race-neutral admissions after finding differences in racial and ethnic makeup of undergrad population and state population. We believe our new policy of admitting the top 10% of all in-state high schools is a fair system that does not consider race or gender, but merely rewards the top academic students. This is not a question of de jure segregation. Race is still a factor in admission for remaining applicants because we hope to create a diverse and accepting community here. UT accepts a large majority of students through the top 10% law. This law protects that UT will have a culturally diverse student community. Although all the accepted students under the top 10% law may not have been the top students in the state due to varying levels of competition in varying schools, the law does maintain that the undergraduate community will be diverse, and here at the university, we strongly believe that having a diverse community will result in a more culturally enriched and diversely knowledgeable student body. Thank you.
I personally believe that the Supreme Court should and will decide against Abigail Fisher. According to previous court cases, the Supreme Court has taken strict scrutiny to prove that race can be part of a holistic admissions process. However, race probably had nothing to do with her admissions process. In fact, she probably is against being in a diverse campus. She had a 3.59 GPA, which obviously is relative to the school district. However, she could have shown her intelligence or her SAT score. She only received an 1180, which is barely in the 50th percentile for UT admissions. She didn't even acknowledge the Hispanics and African Americans who were denied admissions that had better or equal grades to her, or the whites who had worse grades than her and that were accepted. Also left unstated was that she turned down a standard UT offer under which she could have gone to another UT school at a campus other than Austin her first year, earn a 3.2 GPA, and enter Austin her sophomore year, but she was completely adamant and stubborn about attending Austin her first year specifically. Although I do believe that affirmative action does discriminate in some ways and that it should be reformed by supporting students with underprivileged socioeconomic backgrounds and not entirely race, it shouldn't matter that race is a small factor in admissions decisions. College admissions is based on several different components, and for her to complain about race isn't entirely validly supported. There are students who get rejected from Harvard with 2400s and 4.0s with different racial backgrounds, so it's not the end of the world for her.
Those insights. If Fisher wins, the Supreme Court will overrule the previous Grutter versus Bollinger case and would likely end affirmative action at public universities. Thus, some schools might show a decrease in diversity. We'll revert back to the 14th Amendment in the Equal Protection Clause that the government in higher education cannot deny any person equal protection under the law and repeal the 10% law. If Fisher wins, the Equal Protection Clause will be upheld. It is also possible that diversity can still be achieved if students of African American and Hispanic backgrounds continue to improve their GPA and SAT scores. If UT wins, which is the favored scenario, diversity will continue to be obtained by continuing to apply to the top 10% law and apply that the top 10 percentile will draw from the naturally segregated school system. De jure segregation continues. Race on application continues as a consideration for acceptance. The ruling of Grutter will still be in effect, which states that colleges are allowed to consider race when reviewing applicants, and that does not interfere with the 14th Amendment. Thank you for following us here on AA.